Banking and special commercial laws. What is a letter of credit? A letter of credit is any arrangement, however named or described, whereby a bank, acting upon the request of its client or on its own behalf, agrees to pay another against stipulated documents, provided that the terms of the credit are complied with. Doctrine of independence. By this doctrine, the relationships among a. the issuing bank and the beneficiary, b. the issuing bank and the applicant, and c. the beneficiary and the applicant, while interrelated, are separate, distinct, and independent of one another. Thus, in determining the obligation of the issuing bank to pay the beneficiary, the issuing bank has no obligation to verify whether or not the main contract has been fulfilled or not. The issuing bank is liable to pay the beneficiary upon the latter's submission of the stipulated documents and compliance with the terms of the credit, regardless of any breach of contract by the beneficiary to the applicant of the letter of credit. Conversely, the right of the issuing bank to obtain reimbursement from the applicant of the letters of credit is not adversely affected by the non-fulfillment by the beneficiary of its obligation to the applicant. Where is the doctrine of independence derived? Article 17 of UCP 400 explains that under this principle, an issuing bank assumes no liability or responsibility for the form, sufficiency, accuracy, genuineness, falsification, or legal effect of any documents, or for the general and or particular conditions stipulated in the document or superimposed thereon. Thus, as long as the proper documents are presented, the issuing bank has an obligation to pay even if the buyer should later on refuse payment. To allow issuing bank to refuse to honor the letter of credit simply because it could not collect first from the buyer is to countenance a breach of the independence principle. The Hong Kong and Shanghai Banking Corporation Limited Petitioner versus National Steel Corporation and City Trust Banking Corporation, now Bank of the Philippine Islands, GR 183486, February 24, 2016. SMC accredited B as one of its dealers authorized to sell SMC beer products. As required by the terms of the dealership, B obtained a credit line from ABC Bank, and that in case of purchase by B from SMC, the latter may draw on the credit line, and such drawdown shall be considered loan availments on the part of B. The obligation of B under the dealership agreement secured by a letter of credit issued by ABC Bank. B failed to pay certain purchase orders. SMC filed an action for collection against B and ABC Bank. The court rendered judgment finding B solely liable to pay SMC and omitted by inadvertence to insert in its decision the phrase "without prejudice to the decision that will be made against ABC." May the bank avoid responsibility on this ground? No. The obligation of B to pay under its agreement with SMC is distinct and independent from the right of SMC to draw on the letter of credit. Under the independence principle, the seller or beneficiary is assured of prompt payment independent of any breach of the main contract, and precludes the issuing bank from determining whether the main contract is actually fulfilled or not. Fraud exception principle. The fraud exception principle is an exception to the doctrine of independence. Under the fraud exception principle, the beneficiary may be enjoined from collecting on the letter of credit if the following elements are present. A. There is fraud on the part of the beneficiary. B. Fraud must be in relation to the independent purpose or character of the credit. C. Unless the beneficiary is restrained, the applicant shall suffer grave and irreparable injury. For the fraud exception principle to serve as an exception to the doctrine of independence, the fraud must not be in relation to the performance of the main contract, but in relation to the independent purpose or character of the credit. Doctrine of strict compliance. Under this doctrine, the documents that the beneficiary should submit to the issuing bank or confirming bank must strictly conform to the documents stipulated. If there is discrepancy, the issuing bank is not liable to pay. If it pays despite discrepant documents, it pays at its own risk and cannot obtain reimbursement from the applicant. It is not a question of whether or not it is fair or equitable to require submission of documents, but whether or not the documents were agreed upon, in which case all such documents must be submitted. Trust Receipts Law. What is a trust receipt? Trust receipt is a transaction between the entrustor and the entrustee, whereby the entrustor who owns or holds absolute title or security interest over credit goods, documents, and instruments releases the same to the possession of the entrustee upon the latter's execution and delivery of a trust receipt, wherein the entrustee binds himself to hold the designated goods, documents, and instruments in trust for the entrustor and to sell or otherwise dispose of the goods or instruments with the obligation to turn over to the entrustor the proceeds thereof to the extent of the amount owing to the entrustor, or to return them to the entrustor in case of non-sale. No, in a trust receipt transaction, the entrustee has the obligation to deliver to the entrustor the price of the sale, or if the merchandise is not sold, to return the merchandise to the entrustor. There are therefore two obligations in a trust receipt transaction. The first refers to money received under the obligation involving the duty to turn it over to the owner of the merchandise sold, while the second refers to the merchandise received under obligation to return it to owner. BSP cannot foreclose the real estate mortgage that secures the loan under a promissory note if what was assigned to BSP is the PN with trust receipt agreement, not the REM. Bangko Sentral ng Pilipinas versus Agustin Libo on GR 173864, November 23, 2015. Distinguished letter of credit from trust receipt. A letter of credit is any arrangement, however named or described, whereby a bank, acting upon the request of its client or on its own behalf, agrees to pay another against stipulated documents, provided that the terms of the credit are complied with. Then add the following. 1. There are two basic parties in a trust receipt, the entrustor and the entrustee, whereas there are the parties to a letter of credit, the applicant or account party, who is the importer in a commercial letter of credit, or the obligor in a standby credit or letter of credit. The beneficiary, who is the exporter in a commercial letter of credit, and obligee in a standby letter of credit, and the issuing bank. Additionally, parties may be involved depending on the need to engage a correspondent bank. Number 2. In a letter of credit, the failure of the account party to reimburse the issuing bank will only give rise to civil liability, whereas the failure of the entrustee to deliver the proceeds of the sale of the goods under trust receipt, or to return the same in case of non-sale, will give rise to criminal liability. Are all obligations of the entrustee criminal in nature? No. Only the failure of the entrustee to deliver the proceeds of the sale of the goods or instruments subject to the trust receipt up to the extent of the amount owing to the entrustor, or to return the goods. Such violation constitutes estafa. Under recent jurisprudence, however, the penal sanction under the trust receipts law does not apply in case the goods are not intended for sale or resale or to manufacture items intended for sale or resale, such as when they are for actual use. Transaction considered a loan even though denominated as a trust receipt. Number 1. If the entrustee is already the owner or in possession of the goods before delivery of the loan and execution of the trust receipt agreement, the transaction shall be considered a simple loan, even though the parties may have denominated the agreement as one of trust receipt. To be in nature of the trust receipt, the entrustor should have financed the acquisition or importation of the goods. The funds should have been delivered before or simultaneously with delivery of the goods. Number 2. If the goods subject of the trust receipt are not intended for sale or resale. Number 3. Sale of goods by a person in the business of selling goods for profit who at the outset of the transaction has as against the buyer general property rights in such goods, and the seller agrees to hold the proceeds of the sale of such goods to his creditor under a supposed trust receipt transaction. D owns 100 sacks of rice, which he sold to B. D obtained a loan from C, secured by the proceeds of sale of the rice from B, which D agrees to hold in trust for C. D and C denominated the transaction as one of trust receipt. Is such transaction a trust receipt within the ambit of the trust receipt law? No. There is no trust receipt, notwithstanding the label, if goods offered as security for loan, accommodation, or goods owned and sold by the seller who at the outset of the transaction has against the buyer general property rights over such goods. Remedies available to the entrustor in case of violation of the trust receipt agreement. 1. File a criminal case for estafa in case of failure of the entrustee to deliver the proceeds of the sale of the goods under trust receipt up to the extent of his obligation to the entrustor. The civil action may be instituted in a criminal action or separately filed independently of the criminal action. The criminal action is based on ex delicto for violation of the law, while the civil action is based on ex contracto for violation of the trust receipt agreement. Number 2. Cancel the trust and take possession of the goods at any time upon default of the entrustee. After repossession, the entrustor may sell the goods upon at least 5 days' notice to the entrustee and apply the proceeds in payment of the obligation. The entrustee is liable for deficiency or entitled to excess, if any. 3. If a surety secures the obligation of the entrustee in addition to the trust receipt, the law does not obligate the entrustor to cancel the trust or take possession of the goods. He can proceed against the surety. The options belong to the entrustor. Banking laws. Monetary Board powers. It is settled that the power and authority of the Monetary Board to close banks and liquidate them thereafter when public interest so requires is an exercise of the police power of the state. Police power, however, is subject to judicial inquiry. It may not be exercised arbitrarily or unreasonably and could be set aside if it is either capricious, discriminatory, whimsical, arbitrary, unjust, or is tantamount to a denial of due process and equal protection clauses of the Constitution. Nothing in Section 30 of RA 7653 requires the BSP, through the Monetary Board, to make an independent determination of whether a bank may still be rehabilitated or not. As expressly stated in the aforementioned provision, once the receiver determines that rehabilitation is no longer feasible, the Monetary Board is simply obligated to A. notify in writing the bank's board of directors of the same, and B. direct the PDIC to proceed with liquidation. Apex Bankwrights Holding, Lead Bank Fund Holdings et al. Versus Bangko Sentral ng Pilipinas and Philippine Deposit Insurance Corporation, GR 214866, October 2, 2017. Distinguish conservator from receiver. A conservator is appointed if the bank is in continuing state of illiquidity, meaning its assets are more than liabilities but are not in cash or readily convertible to cash, whereas a receiver is generally appointed if the bank is insolvent. A conservator takes charge of the assets, liabilities, and management of the bank in distress, whereas a receiver shall immediately gather and take charge of all the assets and liabilities of the institution, administer the same for the benefit of its creditors, and exercise the general powers of the receiver under the rules of court. A conservator has 1 year from appointment to rehabilitate the bank, whereas the receiver has 90 days to do so. Otherwise, they shall recommend to the MB or monetary board the liquidation of the bank. The court has no authority to appoint a conservator or receiver for a bank in financial distress or place it under a management committee. Such authority is lodged with the BSP. Resolution of the BSP issued in the exercise of its quasi-judicial functions, like imposing sanctions for violations of banking laws or regulations, or appointing a receiver or conservator or closing a bank, is not subject to declaratory relief. Requisites to assail the order of BSP appointing a receiver or conservator or closing a bank. The order of conservatorship, receivership, or closure may be assailed by A. the stockholders representing at least majority of the outstanding capital stock, B. within 10 days from receipt by the board of directors of the order, C. to a petition for certiorari with the Court of Appeals on the ground that the action taken by BSP was in excess of jurisdiction or with grave abuse of discretion as to amount to lack of jurisdiction. RTC, acting as a liquidation court, has no power to overrule the findings of the monetary board. It cannot pass upon the issue of whether or not the order of closure is valid. In fact, the liquidation court's authority is limited to adjudicating disputed claims against the institution, assisting the enforcement of individual liabilities of the stockholders, directors, and officers, and deciding on the other issues to implement the liquidation plan. The exclusivity of the monetary board's power is highlighted by the absence of appeal from its actions under Section 30 of RA 7653. Monetary board's actions are final and executory and can only be set aside by filing a petition for certiorari within 10 days from receipt by the bank's board of directors of the MB's order directing the receivership, liquidation, or conservatorship. USECA versus PDIC as the statutory liquidator of the Unitrust Development Bank. September 28, 2016, GR 217899. Law and Secrecy of Philippine Currency Bank Deposits, RA 1405. Laws and Secrecy of Bank Funds. Republic Act 1405, which expressly provides that all deposits of whatever nature with banks or banking institutions are hereby considered as an absolutely confidential nature and may not be examined, inquired, or looked into by any person, government official, bureau, or office except upon the limited instances provided therein. The Foreign Currency Deposits Act, RA 6426, which provides that all foreign currency deposits are hereby declared as and considered of an absolutely confidential nature, and except upon the written permission of the depositor, in no instance shall foreign currency deposits be examined, inquired, or looked into by any person, government official, bureau or office, whether judicial or administrative or legislative, or any entity, whether public or private. The General Banking Act, which provides that no director, officer, employee, or agent of any bank shall, without order of a court of competent jurisdiction, disclose to any unauthorized person any information relative to the funds or properties in the custody of the bank belonging to private individuals, corporations, or any other entity. Section 55-1, letter B. In what cases may information on Philippine currency bank deposits, as well as investment in government securities, be disclosed, examined, or looked into without violating the law? Number 1. Written permission of the depositor. Number 2. In case of impeachment. Number 3. In case of order of a competent court in any of the following cases. 1. In case of bribery or dereliction of duty of public officials. 2. Where the subject matter of litigation is the money deposited. 3. Prosecution for unexplained wealth. Plunder is akin to unexplained wealth. 4. Prosecution for violation of the Anti-Graft and Corrupt Practices Act. 5. In case of prima facie violation of the anti-money laundering law. Note: disclosure can only be made to the Anti-Money Laundering Council. Bank inquiry order is not necessary if the predicate crime is kidnapping, hijacking, arson, murder, and violation of the dangerous drugs law or terrorism. Number 6. Garnishment of bank deposits. Note further that the train law removed the provision on the authority of BIR to look into the deposits of deceased taxpayer for the purpose of computing tax on the estate, since withdrawal of such deposits is subject to 6% withholding tax. Number 4. The BIR may also inquire into bank deposits if there is an offer of compromise of tax liability on account of financial incapacity to verify such representation of the taxpayer. Number 5. Under the unclaimed balances law, the bank may disclose to the National Treasurer information concerning dormant deposits for the purpose of initiating escheat proceedings. Number 6. In case the law is repealed, superseded, or modified by any law to the contrary, may the bank disclose information about Philippine currency bank deposits pursuant to a writ of garnishment? The bank may disclose information about Philippine currency bank deposits pursuant to a writ of garnishment. The disclosure in this case is only incidental to the execution process. There is nothing in the records of Congress that would show the intention of legislature to place Philippine currency bank deposits beyond the reach of judgment creditor. Foreign currency deposits, however, are exempt from garnishment or any court or administrative process. However, the exemption of foreign currency deposits from court order and administrative processes cannot be invoked in case of violation of the anti-money laundering law, or if property or funds are related to financing of terrorism or acts of terrorism, or by a person who is not the owner of the FCTU account, or against a co-owner of the account, or by a transient for any purpose contrary to that intended by law, which is to encourage foreign currency deposits to beef up our international reserves. The inquiry into bank deposits allowable under RA 1405 must be premised on the fact that money deposited in the account is itself the subject of the action. Where the information filed in court charged respondent with qualified theft, the subject matter of litigation is the money alleged to have been stolen by the respondent. Thus, where the subject matter of the testimonial and documentary evidence is not at all relevant to the case, the suppression of such testimony is valid. Otherwise, it constitutes an attempt by the prosecution at an impermissible inquiry into a bank deposit account, the privacy and confidentiality of which is protected by law. BSP Group, Incorporated versus Go, GR 168644, February 16, 2010. Republic Act 6426 is a special law designed especially for foreign currency deposits in the Philippines. RA 1405, which covers all bank deposits in the Philippines, is the general law which does not nullify the special law on foreign currency deposits. The surety, which issued a bond to secure the obligation of the principal debtor, cannot inquire into the foreign currency deposits of the debtor, even if its purpose is to determine whether or not the loan proceeds were used for the purpose specified in the surety agreement. The foreign currency deposits cannot be examined without the consent of the depositor. The subpoena issued by the bank should be quashed because foreign currency deposits are not subject to court order except for violation of the anti-money laundering law. GSIS versus Court of Appeals, GR 189206, June 8, 2011. Section 2 of RA 1405, the law on secrecy of bank deposits, provides for exceptions when records of deposits may be disclosed. These are under any of the following instances: A, upon written permission of the depositor; B, in case of impeachment; C, upon order of a competent court in the case of bribery or dereliction of duty of public officials; D, when the money deposited or invested is the subject matter of the litigation; and E, in cases of violation of the Anti-Money Laundering Act. The Anti-Money Laundering Council may inquire into a bank account upon order of any competent court. The joint motion to approve agreement executed by the parties on waiver of confidentiality of its bank deposits does not bind the depositor who was not a party and signatory to the said agreement. Doña Adela Export International versus Trade and Investment Development Corporation, February 11, 2015, GR 201931. General Banking Act. What is a bank? A bank is an entity engaged in the lending of funds obtained from the public in the form of deposits. A transaction involving not a loan, but purchase of receivables at a discount within the purview of investing, reinvesting, or trading in securities which an investment company may perform is not banking. What is prohibited is for investment company to lend funds obtained from the public through receipts of deposits, which is a banking function. Prohibited acts. 1. Single borrower's limit. 2. Loans granted to its directors, officers, stockholders, and their related interests must comply with certain requirements. Otherwise, the erring DOSRI or directors, officers, stockholders, and their related interests may be held criminally and administratively liable. What do you mean by the single borrower's limit? Unless otherwise prescribed by the Monetary Board, the total amount of loans, credit accommodations, and guarantees that may be extended by a bank to a single borrower shall not exceed 25% of the net worth of such bank. The amount may be increased by an additional 10% of the bank's net worth, provided that the additional liabilities are adequately secured by documents of title covering readily marketable and non-perishable goods. What are the rules governing transactions where Directors, officers, stockholders, and their related interests, or DOSRI, may incur contractual obligation with their banks. No director, officer of any bank shall directly or indirectly for himself or as the representative or agent of others borrow from such bank, nor shall become a guarantor, endorser, or surety for loans from such bank to others, or in any be an obligor, or incur any contractual liability to the bank except with the written approval of at least majority of all the directors of the bank, excluding the director concerned. The required approval shall be entered upon the records of the bank, and a copy of such entry shall be transmitted forthwith to the appropriate supervising and examining department of BSP. The outstanding loans, credit accommodations, and guarantees which a bank may extend to the DOSRI shall be limited to an amount equivalent to the respective unencumbered deposits and book value of their paid-in capital contribution to the bank. A loan transaction that does not comply with the rules on DOSRI and or single borrower's limit is valid but without prejudice to criminal prosecution against the parties responsible for the violation. Philippine Deposit Insurance Corporation. In one case, an investor placed his funds in a money market placement with a finance company. On maturity, the invested funds cannot be paid owing to the insolvency of the finance company, but the latter referred the investor to its bank affiliate, which thereafter issued a certificate of deposit to the same investor. The deposit was likewise not paid because the bank eventually closed. The investor filed an insurance claim covering the supposed deposit. PDIC denied it. The legality of the denial was thereafter assailed. The High Court sustained the PDIC, ruling that the liability of PDIC is statutory. It is based on the actual receipt by the Bank of Deposits, not on a mere certification on the existence of deposit. PDIC v. Court of Appeals, 283 SCRA 462. In another case, PDIC also denied the insurance claim when it discovered that the money allegedly placed with the insured bank was actually credited to the personal account of the bank president, and the certificates of time deposits, CTD, were not duly issued by the bank but were merely replicas of unissued CTDs in the inventory submitted by the bank with PDIC. The Supreme Court found no grave abuse of discretion on the part of PDIC, holding that PDIC's acts were consistent with law. Spouses Chugani v. Philippine Deposit Insurance Corporation, GR 2337, March 19, 2018. Deposit accounts not entitled to payment. PDIC shall not pay deposit insurance for the following accounts or transactions, whether denominated, documented, recorded, or booked as deposit by the bank. IFUL investment products such as bonds and securities, trust accounts, and other similar instruments, deposit accounts, or transactions which are unfunded or that are fictitious or fraudulent deposit accounts, or transactions consisting unsafe and unsound banking practices as determined by PDIC in consultation with BSP after due notice and learning and publication of a cease and desist order issued by the PDIC against such deposit accounts or transactions, and deposits that are determined to be the proceeds of an unlawful activity as defined under the anti-money laundering law. Prohibition against splitting of deposits. Splitting of deposits occurs whenever a deposit account with an outstanding balance of more than the statutory maximum amount of insured deposit maintained under the name of natural or juridical persons is broken down and transferred into two or more accounts in the names or name of natural or juridical persons or entities who have no beneficial ownership on transferred deposits in their names within 120 days immediately preceding or during a bank declared holiday or immediately preceding a closure order by the BSP for the purpose of availing of the maximum deposit insurance coverage. Such splitting of deposit is punishable by imprisonment and or fine. In one case, the Supreme Court even held that monies deposited by individuals who benefited from the unlawful splitting of deposits are considered laundered funds. Philippine Deposit Insurance Corporation versus Kidwani, June 20, 2018. Prohibition against issuance of TRO. No court, except the Court of Appeals, shall issue any temporary restraining order, preliminary injunction, or preliminary mandatory injunction against PDIC for any action on its part under the PDIC Charter. The Supreme Court may issue temporary restraining order or injunction when the matter is of extreme urgency involving a constitutional issues, such that unless a TRO is issued, grave injustice or irreparable injury will arise. The actions of PDIC with respect to determine of insured deposit accounts shall be final and executory, and may not be set aside or restrained by the court except on petition for certiorari on the ground that the action was taken in excess of jurisdiction or with grave abuse of discretion as to amount to lack or excess of jurisdiction. The petition for certiorari may only be filed within 30 days from notice of denial of claim for deposit insurance. So versus Philippine Deposit Insurance Corporation, GR 2300-20, March 19, 2018. The Regional Trial Court has no jurisdiction to nullify the action of PDIC in denying insurance claim. Espousos Chugani versus PDIC. Anti-Money Laundering Law, RA 9160 as amended by RA 10365. Who are the covered institutions or persons under the Anti-Money Laundering Law? 1. Institutions supervised or regulated by BSP. Number 2. Institutions supervised and regulated by the Insurance Commission. 3. Entities dealing in currency, commodities, or financial derivatives based thereon, valuable objects, cash substitutes, and other similar monetary instruments or property supervised and regulated by the Securities and Exchange Commission. 4. Jewelry dealers in precious metals who, as a business, trade in precious metals for transaction in excess of 1 million pesos. 5. Jewelry dealers in precious stones who are as a business trade in precious stones for transactions in excess of 1 million pesos. 6. Company service providers which, as a business, provide any of the following services to third parties. 1. Acting as a formation agent of juridical persons. 2. Acting as or arranging for another person to act as director or corporate secretary of a company, a partner of a partnership, or a similar position in related to other juridical persons. 3. Providing a registered office, business address or accommodation, correspondence or administrative address for a company, a partnership, or any other legal person or arrangement. And 4. Acting as or arranging for another person to act as a nominee, shareholder for another person. And 7. Persons who provide any of the following services. 1. Managing of client money, securities, or other assets. 2. Management of bank, savings, or securities accounts. 3. Organization of contributions for the creation, operation, or management of companies, and 4. Creation, operation, or management of juridical persons or arrangements in buying and selling business entities. Notwithstanding the foregoing, the term covered persons shall exclude lawyers and accountants acting as independent legal professionals in relation to information concerning their clients, or where disclosure of information would compromise client confidences or the attorney-client relationship, provided that these lawyers and accountants are authorized to practice in the Philippines and shall continue to be subject to the provisions of their respective codes of conduct and or professional responsibility or any of its amendments. NB single cash transaction involving an amount in excess of 5 million or its equivalent in any other currency is a covered transaction. RA 10927. Obligations of covered institutions or persons. Customer identification. 2. Record keeping. Records should be kept and safely stored for 5 years from date of the transaction. 3. Reporting of covered and suspicious transactions. When is money laundering committed? Money laundering is a crime whereby the proceeds of unlawful activity are transferred, thereby making them appear to have originated from legitimate sources. It is committed by the following. Money laundering is committed by any person who, knowing that any monetary instrument or property represents, involves, or relates to the proceeds of any unlawful activity, A. Transacts said monetary instrument or property, B. Converts, transfers, disposes of, moves, acquires, possesses, or uses said monetary instrument or property, C. Conceals or disguises the true nature, source, location, disposition, movement, or ownership of or rights with respect to said monetary instrument or property. D. Attempts or conspires to commit money laundering offenses referred to in paragraph A, B, or C. E. Aids, abets, assists in, or counsels the commission of the money laundering offenses referred to in paragraph A, B, or C. And F. Performs or fails to perform any act, as a result of which he facilitates the offense of money laundering referred to in paragraphs A, B, or C above. Money laundering is also committed by any covered person who, knowing that a covered or suspicious transaction is required under this Act to be reported to the Anti-Money Laundering Council, AMLC, fails to do so. What is the meaning of safe harbor provision under AMLA? No administrative, criminal, or civil proceedings shall lie against any person for having made a covered transaction or suspicious transaction report in the regular performance of his duties and in good faith, whether or not such reporting results in any criminal prosecution under the AMLA or any other Philippine law. Bank inquiry and freeze orders. For the trial court to issue bank inquiry order, it is necessary for the AMLC to be able to show specific facts and circumstances that provides a link between an unlawful activity or a money laundering offense, on the one hand, and the account or monetary instrument or property sought to be examined on the other hand. Republic of the Philippines, represented by the Anti-Money Laundering Council versus Jocelyn Bolante, GR 186717, April 17, 2017. Section 11 of the AMLA, providing for ex parte application and inquiry by the AMLC into certain bank deposits and investments, does not violate substantive due process, there being no physical seizure of property involved at that stage. It is the preliminary and actual seizure of the bank deposits or investments in question which brings this within reach of the judicial process, specifically a determination that the seizure violated due process. SPCMB's constitutional right to procedural due process is likewise not violated by the ex parte application and inquiry by the AMLC into certain bank deposits and investments. AMLC does not possess quasi-judicial powers, and hence it has no adjudicatory power. AMLC's investigation of money laundering offenses and its determination of possible money laundering offenses, specifically its inquiry into certain bank accounts allowed by court order, does not transform it into an investigative body exercising quasi-judicial powers. Taking into account Section 11 of the AMLA, the court found nothing arbitrary in the allowance and authorization to AMLC to undertake an inquiry into certain bank accounts or deposits. Instead, the court found that it provides safeguards before a bank inquiry order is issued, ensuring adherence to the general state policy of preserving the absolutely confidential nature of Philippine bank accounts. A. The AMLC is required to establish probable cause as basis for its ex parte application for bank inquiry order. The CA, independent of the AMLC's demonstration of probable cause itself, makes a finding of probable cause that the deposit or investments are related to an unlawful activity under Section 3, letter I, or a money laundering offense under Section 4 of the AMLA. 3. A bank inquiry court order ex parte for related accounts is preceded by a bank inquiry court order ex parte for the principal account, which court order ex parte for related accounts is separately based on probable cause that such related account is materially linked to the principal account inquired into. And 4. The authority to inquire into or examine the main or principal account, that the related account shall comply with the requirements of Article 3, Section 2 and 3 of the Constitution. Bound by these requirements for issuance of a bank inquiry order, Section 11 of the MLA, the court are hard-pressed to declare that it violates SPCMB's right to privacy. 1. Nonetheless, although the bank inquiry order ex parte passes constitutional muster, there is nothing in Section 11 nor the implementing rules and regulations of the AMLA which prohibits the owner of the bank account, as in this instance SPCMB, to ascertain from the CA post issuance of the bank inquiry order ex parte if his account is indeed the subject of an examination. Considering the safeguards under Section 11 preceding the issuance of such an order, the court finds that there is nothing therein which precludes the owner of the account from challenging the basis for the issuance thereof. This allowance to the owner of the bank account to question the bank inquiry order is granted only after issuance of the freeze order physically seizing the subject bank account. It cannot be undertaken prior to the issuance of the freeze order. All told, the court affirmed the constitutionality of Section 11 of the AMLA, allowing the ex parte application by the AMLC for authority to inquire into and examine certain bank deposits and investments. The ex parte inquiry shall be upon probable cause that the deposits or investments are related to an unlawful activity as defined in Section 3, letter I of the law, or a money laundering offense under Section 4 of the same law. To effect the limit on the ex parte inquiry, the petition under oath for authority to inquire must akin to the requirement of a petition for freeze order enumerated in the Title 4 of AM number 051104 SC. contain the name and address of the respondent, the grounds relied upon for the issuance of the order of inquiry, and the supporting evidence that the subject bank deposit are in any way related to or involved in an unlawful activity. If the CA finds no substantial merit in the petition, it shall dismiss the petition outright, stating the specific reasons for such denial. If found meritorious and there is a subsequent petition for freeze order, the proceedings shall be governed by the existing rules and petitions for freeze order in the CA. From the issuance of a freeze order, the party aggrieved by the ruling of the court may appeal to the Supreme Court by petition for review on certiorari under Rule 45 of the Rules of Court, raising all pertinent questions of law and issues, including the propriety of the issuance of a bank inquiry order. The appeal shall not stay the enforcement of the subject decision or final order unless the Supreme Court directs otherwise. Subido, Pagente, Certeza, Mendoza, and Binay Law Offices versus the Court of Appeals, GR 216914, December 6, 2016.